Good afternoon, good morning all. I'm Morgane Taylor from the App Association, and we would like to welcome you all to this third part of our webinar series that has been organized in the context of the upcoming European Commission consultation on the new framework on standard essential patents. And this event will focus on transparency and FRAND methodologies for SEP's evaluation. Small business innovators rely on so-called FRAND licensing terms, fair, reasonable, and non-discriminatory terms to license standard essential patents. And as an association, we want to ensure that a SEP is valued based on its technical merits and scope, rather than the value or the users created by downstream innovators or from its inclusion to a standard. And at the same time, SEP holders should be reasonably compensated for the use of their SEP. It's exactly that compensation which is at the center of the FRAND bargain. In exchange of the inclusion of the patent technology into a standard, the patent holder agrees to license any implementer of FRAND terms, and in return, gain access to a broader market of users willing to license their SEP. On the other hand, potential users of the standard choose to use the standard because they are assured that they will be able to license the patents essential to that standard on FRAND terms. And in most cases, SEP licensors and licensees are able to reach an agreement on FRAND licensing terms. And if they disagree, courts are the best equipped to resolve this disagreement based on the arguments and evidence presented by the parties in each individual cases. However, there are certain issues that remain, and indeed there are different methodologies that are available for the evaluation of SEPs and calculating FRAND rates. But often, litigation has centered around the exact definition of fair, reasonable, and non-discriminatory terms and what that exactly means. And this is why we are organizing this panel to gain some legal, academic, and industry insights into SEP's valuation. But on that note, I'll kick it over to Brian Scarpelli, Global Senior Counsel at the App Association, and who will be able to moderate this panel and introduce the different speakers.
Thank you. Thank you very much. And thanks, Morgane, for that, and welcome everyone. Good morning, good afternoon, good evening, wherever you are. And yes, I'm Brian Scarpelli, Senior Global Policy Counsel with the App Association. Very pleased to be a part of this virtual event, and appreciate you all taking some time to join. These are very timely, important topics, and I think events like these really help move the needle in the public debate and help inform the public debate. So we have a great panelist here. Today's a great panel session here. Today's session is intended to be structured in two parts. First, in a moment, each of the speakers will be invited to give their something of an opening statement or table setting on standard essential patent valuation issues from their angles and their perspectives. And then after that, we can move to a question and answer session where ideally we'll have many questions from you, the audience, that in light of their interventions. To just logistically, to ask a question, you please use the Q&A function on the Zoom platform. And you can see it's like next to participants, in between participants and chat, for example. I don't recommend you use the chat function because your question might get lost there. So feel free to pose your questions at any time during the event, and we'll be collecting them and hopefully able to direct them to the relevant speaker. So I'm excited to introduce today's panel. We have some very prominent speakers who can delve into the standard essential patent world, negotiations from a legislative, academic, and industry perspective. And we're looking for I know each of our panelists here are gonna talk for a little bit of time, probably 7 to 8 minutes each. I think first up we had Dr. Gunther Friedl. He is a professor of business administration at the Technical University of Munich. His research interests span from corporate governance to patent valuation. Dr. Friedl has also carried out research and teaching assignments at both Stanford University and the Warsaw School of Economics. And in 2018, he co-authored a cost-based approach to calculating royalties for standard essential patents. I'd love to hear your initially, Dr. Friedl, your thoughts and your opening framing.
Okay, yeah, thank you very much, Brian, and good afternoon, everybody. It's an honor and pleasure to be on this distinguished panel here, and I'm happy to offer some thoughts on how to value standard essential patents. So first of all, I think when it comes to valuation, the important question always is, what is the value, the economic value, basically, a certain technology has? And this is at the heart of any valuation and any valuation that you should do also when valuing standard essential patents. What has happened over the course of the last years is that several methods basically have turned out to be quite frequently used, not only by licensors and licensees, but also when it comes to disputes in courts. And I think what we observe very frequently are in particular the two methods, the comparable contract method and the top-down valuation method. And they have their distinct strengths and weaknesses, and they also require certain levels of transparency, but they are obviously not everything that you can do when it comes to arriving at the correct valuation. And therefore, I also think that you need to think about calculating the present value, basically, of the invention. Present value method is also something of choice. And the fourth one that I also want to, and you, Brian, you mentioned that initially, the cost-based approach. So just looking at the cost of the patent owners and the development cost that they have, and derive from that perspective what the value could be. I think you need all of these approaches in order to arrive at a reasonable value. If you neglect any of the approaches, then you probably will be misled. And that is also, I would say, supported by what I've observing in the market. You typically make robustness tests for these valuation approaches in order to arrive at the correct value. Let me very briefly comment on these four approaches. So first of all, comparable contracts. I mean, this is obviously the perfect the perfect number if there is a comparable contract. So if there is a contract where licensor and licensee are pretty much the same, if they negotiate under the same conditions, if they basically negotiate at the same time, the same marketplace, then if you have a fully comparable comparable contract, then this is great. But unfortunately, fully comparable contracts typically do not exist. So you can derive from a comparable contract basically an estimate about the value, but it is difficult to get a precise estimate out of that, because you have typically, due to NDAs, due to transparency issues, you basically do not have fully transparency about these comparable contracts. The top-down approach is something that is quite popular even among courts. So the idea is basically you have the value of a product that uses the technology. This value of the product that uses the technology, that you need to basically assign a certain total value of the technology to this product. So what fraction of the product basically is associated with the technology? If you have a car, let's say this is worth 20,000 euro, the connectivity technology is worth maybe 300 euro, whatever. And if you have now this value of technology, then the question is, what is the value that should basically go to the SEP holders? What is this aggregate royalty burden that they should get? And if you have then arrived at a number, then the question is, what is, if you have 20 SEP owners, what is basically the fraction everybody gets? And again, many of these calculations require data that is not really available. And there is a lot of dispute about aggregate royalties. There is a lot of dispute about what fraction of essential patents then the single patent holder has, and so on. The present value approach is very similar to that. It basically says, let's look at the present value of the technology as the basic for the aggregate royalty, and then let's do the same exercise as in the top-down approach. And finally, and I think that is now also something that is not enough considered up to now, the cost-based approach. If you look at the value of the technology, then many patent owners frequently start the discussion with the amount of R&D expenses that they have spent in order to develop the technology. And I think that is a fair that is a fair argument. And I also think that it is a fair argument that these development expenditures should be compensated for. So the holders of standard essential patents should be compensated for their development efforts, and they also should get an appropriate return for that. And that is the basic idea of the cost-based approach. So basically, instead of looking at the value that the patent the technology generates, let's look at the cost that is basically the basis for developing this technology. And in competitive markets, as we see right now in the development of cellular technology, where a number of firms deliberately have decided to go into the development of 5G, later 6G technology, and others have deliberately decided to step out, then the cost of developing the technology is probably pretty close to the value that they generate. This is one of the characteristics of competitive markets, and therefore I think the cost-based approach can also give you another number in evaluating the in order to obtain the correct value of a standard essential patent or of a standard essential patent portfolio. So you see, there is not the one and all approach in patent valuation when it comes to the valuation of standard and essential patents. There are different approaches with the different strengths and weaknesses, and you should be prepared to apply a whole more of them in order to arrive at a reliable value.
Great. Well, thank you for that. Thank you very much. Our next panelist is Mr. Benno Buehler. Mr. Buehler is the Vice President of Charles River Associates in Munich and Brussels. Prior to his role there, Mr. Buehler was a senior member of the European Commission's DG Competition Chief Economist team. Mr. Buehler has shaped the Commission's economic assessment, a number of landmark horizontal and non-horizontal mergers, such as Qualcomm NXP and UK and Telefonica. Aside from Mr. Buehler's 10 years of competition experience, he's also carried out the economic analysis in a number of antitrust matters, such as the Amazon case on parity clauses, as well as in the Samsung and Motorola SEP cases. So thank you, and welcome your some opening thoughts there, and thinking about some of the questions we're going to answer today. Is asymmetry of information an ongoing concern in the process of SEP valuation, and what action should be taken to guarantee that licensing is done at fair, reasonable, non-discriminatory terms, and anything else?
Thank you so much, Brian. And I'm very pleased actually to be here today. Indeed, let me maybe take a step back now that we heard about valuation, and put the focus on transparency, which is one of the main topics of today's conference. Before coming to ideas as to kind of where we are and what we can do to improve the situation, let me maybe also think a little bit about the general situation. So, I mean, we're talking about standardization, and of course, transparency and information is something that is uniformly important for patent negotiations. But standardization and SEPs is a particular class of patents actually, and I would argue that if we're talking about standards where we are trying to improve the uptake and the adoption of standards, then of course we need to be very concerned about ensuring also that transparency is there. Now, why is it so important? I do think that negotiations are done in a very asymmetric situation in standardization, because SEP holders, they are licensing out their patents to many different licensees, but virtually it's always the same patent portfolio. So there is basically one side on the table that has very good information, is entering into the same negotiations, if you want, again, in terms of the substance matter that is negotiated. And then there's, the other side, the licensees, which often need to get licenses of many complementary patents to implement a standard, right? So often we have many SEP holders at a table, so they need to deal with lots of different portfolios. So we have one side that is always dealing with the same portfolio, or like at least when it comes to the same standard. And then the other side, the licensees, have to get into, a range of different patent portfolios. So that's very asymmetric, which means that we need to be very conscious, actually, that the costs of getting into these portfolios is not out of reach, actually, for one of these sides on the table. And I would argue that if one of the two sides is facing constantly new patent portfolios, then of course the risk is more on that side. Then secondly, there's also actually an implication on cost here. I would argue that in many different negotiations on the same standard, the same questions come up. Actually, it's the questions on whether certain patents are essential, are they valid, and so on and so forth. So we need to have an answer on the same questions over and over again. And often there's a discussion as to whether transparency is something that comes at a price and increases transaction cost, or whether it decreases transaction cost. And I would argue actually that if we are looking for the same information over and over again in different negotiations, then having a certain transparency and having certain information publicly available is something that may decrease transaction costs as a whole, and might actually make licensing more efficient, because we need to do certain tasks only once. Then it becomes public information, and then we don't need to kind of reinvent the wheel over and over again, if you want. And this is particularly important in standardization, because especially as we kind of move along and go towards a world of IoT, we have more and more asymmetry also in relation to size, actually, in funding. So we have on the one hand, we have large corporations with big licensing programs. On the other hand, we have small SMEs that we all want to foster, actually, that may lack actually the funding to undertake costly assessments. For example, essentiality, which can easily cost tens of thousands of dollars, and then litigation. So if you want a poor transparency, might actually crowd out certain players in the market, like the SMEs that we want to have actually in the market. So that's why I would say, ensuring transparency is something that I personally find very important, actually. And unfortunately, what we are seeing is not quite there. So the situation, I would actually describe it as quite bleak in all of the dimensions that I've mentioned: essentiality, validity, and then also comparable license information, what Mr. Friedl has mentioned. On all of these dimensions, the requirements are very poor, actually. Now, interestingly, especially in continental Europe, there have been attempts actually to improve this. Right now, there's a big initiative underway at the European Commission. Many of you will know about this, so I'm welcoming actually these steps, and that we are trying to kind of make some progress here. It's also interesting that the ZTE Huawei decision, in my view, is also an attempt actually to increase the transparency and to ensure actually that SEP holders are bringing also certain information to the table before they are asking for injunctions. So that's something that's very important. That's also why I'm quite concerned, to be frank, when I'm German, actually, and if I'm looking into some of the case law that has been generated in the last years, like this will hire, for example, I'm being really quite concerned that that to me it seems almost as an attempt of going back in time, if you want, and I think that there are some achievements in terms of transparency are at risk, actually, when for example the requirements for SEP holders are watered down, if you want. Okay, let me maybe then quickly, in the few minutes that I might have still, to just envisage some measures that I think are really useful. Some measures that are discussed in the public and that I think are easy to implement and should be implemented is, if we start with the ex-ante measures, is, for example, the disclosure of essential patents. There's two different regimes. Like some SDOs require or allow blanket disclosures. Others, require that SEPs be disclosed one by one. Personally, I do think that the latter has many advantages, and I do think actually that imposing actually a declaration, an individual declaration, is something that would benefit actually transparency and then also efficiency of licensing. Second, something that I will only very kind of briefly mention, essentiality checks. I think that's a hot topic actually, and maybe we will just get to this back later in today's discussion. So I will just mention that I think this has pros and cons, but needs to be very carefully considered. And then basically just to put out one instrument on the table that I think is an interesting one is in terms of ex post transparency. NDA, something we need to discuss. Do we really require, very, very extensive NDAs, or in a setting of standardization and the licensing of SEPs? Could it be that there we have, an overriding public interest, and therefore basically we need to be very careful when it comes to NDAs, and maybe also impose restriction as to what's admissible. And then, something that I hope to come back later. I do think that strengthening and that is maybe more like a midterm instrument, strengthening the IPR policies of SDOs is something I think that has great potential. Right now, we have lots of flexibility. We saw that in some examples for like the IEEE clarification, for example, a few years ago. I think this is something that, increases transparency and potentially decreases also the need for litigation. So that's, I think, something that is good, especially if this is done at the stage where an SDO is set up, where basically both sides of the table can then decide whether this is something they like or not. So this is something I think that should be also pushed going forward. I will leave it here for the moment, and then hope to come back on to this later.
Excellent. Thank you for that. Really great. Okay, next we're happy to have Professor Christian Helmers here as a panelist. He's a professor of economics at the Leavey School of Business at Santa Clara University. And Professor Helmers' research primarily focuses on innovation law and economics, in particular in the intellectual property space and the economics of digitization. Professor Helmers has also previously worked as a research economist at the LSE, as well as being a visiting research scholar at UC Berkeley, Stanford, and WIPO, World Intellectual Property Organization. Thanks for being here, and welcome your kind of opening framing. I know, for example, you recently finalized a study addressing transparency of FRAND licensing of 4G and 5G standard essential patents, and maybe as part of that, you could highlight some of the, what you found and reasons for lack of availability in SEP licensing negotiations.
Thanks, Brian, and thanks for the invitation to participate in this panel. Maybe let me talk a little bit about this recent article that we wrote about price transparency in the 4G and 5G licensing market, because I think that's a fairly good example of the issues that characterize, I think, other standards as well. So the way, at least we thought in this article, and this was joint work with my co-author at the law school at Santa Clara, Brian Love, the way we think about transparency is really as transparency with respect to information, the amount of information and who actually has that information, with respect to essentially three questions. The first one is who needs a license? So do I really need to license that patent, or as an SEP owner, you ask like who needs to license my SEP patents, and that's essentially about essentiality, right? The other question is, once you've decided whether you need to license or not, what are the appropriate terms of the license, right? And this is mostly about price, although of course terms are much broader defined than that. And then finally, there's a question about discriminatory licensing. So once you've determined that you need to license, you figured out the terms that you believe are appropriate, there's still a question whether you're actually paying more or less than similarly situated companies. So those three questions, I think, are relevant when we talk about transparency, and sometimes I think they're mixed together and they're all interrelated, obviously. What we did in our studies, we try to set aside questions about essentiality, validity, and just focus on price. And the idea was very simple. We essentially tried to confirm something that I think every practitioner knows, which is that there is relatively, to a certain extent, perhaps surprisingly little information on prices publicly available. So we made a reasonable effort to actually collect all the available price points on 4G and 5G licensing of SEPs. And we really, went out and collected all available data, not just court decisions or arbitrations. So we tried to really find everything that anyone could possibly find. The result won't surprise anybody, which is that there is very little information out there. And what is more is that the information that's out there is almost impossible to interpret. Why? Well, because even when royalty rates are available, there's a lot of information missing that would help you put those numbers into context. And the other issue is that often those numbers are just flat numbers, just dollar amounts, and then it's almost impossible to actually even extract rates from those amounts. But that's actually what's out there. And this is for a technology like 4G or 5G, where, if anything, we have the largest amount of data available simply because it's so widely used, it's received an enormous amount of public attention, and it's been litigated a lot in the courts, right? So, but even for this technology, there's very little information available. So the more interesting point, perhaps, then is why is that? And actually, we don't have an answer. We don't know why. But one thing that we discovered, which I think might also be obvious to practitioners, is that it is somehow the outcome of a consensus in the industry, right? And it's not just SEP owners, it's actually both sides, SEP owners and implementers, that somehow agree to exposed secrecy, in the sense that once they have come to an agreement over the terms of a license, there is a consensus to keep that information secret, right? So Dr. Buehler already mentioned NDAs, so that's just a common practice in the industry. Licensing terms are treated as trade secrets. But really, I want to emphasize that this is driven by both parties. It's not something that's just being imposed by SEP owners on implementers. And interesting case in point here is the Unilog versus Apple case, right, where the court recently refused to seal over 100 licensing deals by Unilog. And then when Unilog opposed that, Apple, the defendant, the implementer, actually joined Unilog, right? And they both tried to convince the court not to disclose those licenses. And of course, I think the motivation by Apple was that this type of transparency would ultimately also harm the implementer Apple, right? So this is something I think that is important to notice, especially regulators who are interested in increasing transparency. That first it might be interesting to figure out why that is. Why is this an industry consensus? And there might be a straightforward answer to that. As far as I know, there is not. So I've heard all kinds of explanations for why that is. Some make more economic sense, others less, but it's definitely not a single answer as far as I'm aware. So why does this all matter? Well, it could potentially matter a great deal, but again, that's not obvious. We don't know. But it essentially means that if there's so little price transparency, that negotiations, when it comes to the terms of a licensing agreement, there will be case by case. This is essentially what we currently have, right? And that negotiation will take place under asymmetric information. This has implications for example, search costs. There will be enormous search costs involved in setting up licensing agreements. Those search costs might matter very little to the big players in the industry. In fact, if you're an incumbent, and these are firms that often find themselves on both sides as licensors and licensees, they might have more information. For them, the search costs will be minor. That won't matter much. But when we think about smaller firms, especially now in the context of the Internet of Things, this might actually matter much more, and it might potentially deter some new entrants in the market from adopting these technologies simply because they cannot ex ante figure out what the potential price of a license would be, right? So inexperienced licensees, I think they will be most affected by this. And another issue, I think, is that the lack of price transparency also provides opportunities for opportunism. So Brian Love and I, we've also been doing work on trying to study empirically hold up and hold out. And at least in my view, a lot of this discussion comes down to, are we paying the right price, right? From a licensee's perspective, and from a licensor's perspective is, are we getting the money that's actually due to us? And that's also just about price in essence, right? And these questions are really, really difficult to answer in the absence of information on price. And that concerns the parties, but it also concerns policymakers. So something that is interesting is that we have a lot of policy discussion right now, but a lot of this discussion is actually focused on very, very little information, right? The data points that we actually have available, which mostly come from court decisions in the US as well as Europe, but now also to a certain extent beyond. But these are very, very few data points. And those data points might actually receive far too much attention in the current policy debate, and they might actually also direct policy, despite the fact that these are not representative data points by a far stretch. Right? So that's also something I think that is important to keep in mind. So bottom line, there's little transparency, price transparency in the market for SEP licensing. Everybody knew that already. Why is that? The answer is we don't know. But I think the more interesting aspect here is that this seems to be, a consensus and equilibrium in this industry. So if policymakers or even market participants wanted to change that, I think a first step would be to try to understand why that is. Like, who benefits currently from the situation? Or is it a situation where intervention is warranted because it's a basic collective action problem? Everybody would benefit if the information were publicly available, but nobody wants to be the first to put it out there because they are afraid that would put them at a competitive disadvantage. Back to you, Brian.
Thank you. Excellent. Appreciate that. Okay. And last but not least, our final panelist is Dr. Andreas Kramer. Dr. Kramer is a partner at Vossius, specializing in intellectual property law. He has been practicing in intellectual property at several well-known law firms since he was admitted to the bar in 2009. His IP expertise ranges from domestic and foreign patent infringement, including areas related to antitrust-based FRAND defenses to proceedings that concern non-technical IP rights, in particular design, trademark, and unfair competition law. So great to have you here as well. And, welcome your opening remarks, and just thinking about, in light of your experience, perhaps part of that could address, what you think about courts potentially being tasked with the job of assessing whether evaluation was carried out fairly, and if there's a greater chance of disclosure in court proceedings moving forward.
Yeah, thank you so much, Brian. Thanks for having me on this panel. It's always a pleasure to discuss with you guys. I'm happy to provide some insights from a German litigation standpoint. A lot of German panelists here. Benno has also mentioned the German case law already. So, but there is a reason why there are so many Germans here, and in particular litigators on this panel, and that is because a lot of patentees chose Germany as a destination for patent litigation. And in these days, we are representing implementers in the first place. And then, always these questions come up, right? So we have done some, calculations, approaches, top-down, comparable licenses. So can we rely on this in litigation in terms of our defense, right? And in German litigation, you can rely, on the obligation to get a FRAND license in terms of a defense. That is the so-called FRAND defense that you raise against the claims for injunctive relief, right? So, and the German courts have a track record of patentee-friendly decisions, and that is why it is such a highly used destination in litigation. And Benno has also mentioned the Sys Hire case law of 2020, right, where the implementers were held unwilling. So the FRAND defense was dismissed from the outset. That is a very, very important case law to note, right? And this case law has been, I would say, over-interpreted by the lower courts to the extent that we have seen a lot of decisions recently where the implementers were held unwilling from the outset for various reasons, for not responding to in a timely manner, for various reasons, right? And that those reasons were far remote from the reasons in Sys Hire, where it was said we will only take a license when the patent will be considered valid and infringed and things like that. So we have seen a lot of those decisions. Why am I saying that? Because in those constellations, the methodologies and transparency does not play a role at all, because the case will be dismissed. And even if you come over this hurdle of willingness and you come to those methodologies, we have heard about the top-down approach, the comparable licenses. So how does this play out in court proceedings? Let's start with the top-down approach. So sometimes you come up with a top-down approach, you present it to the court, and then you say, well, the FRAND rate should be much lower than what the patentee has asked for. And in that aspect, other than with the courts in the UK or so, that admittedly, they appear to have more time to really dig into this. The German judges, they have a heavy workload, and that sometimes also leads to pragmatic approaches. So the pragmatic approach with top-down here with the court is that once the patentee refers to several license agreements that were concluded with third parties, those terms will be considered as fair and reasonable by the courts. So in these scenarios, the courts will not look into the top-down approach that provides for likely significantly lower rates. So they will just move ahead. They will say, well, other players have accepted, so that is fair and reasonable. And then it goes on with comparable licenses. So that is the main playing field in German litigation, to be honest. And there is where also implementers should look at in the first place. And most cases in Germany in this regard have been decided on discrimination and hidden discounts and things like that. So you have to look into this in detail. And that then comes down to transparency. So is there sufficient transparency? There was some case law in the earlier days after Huawei ZTE, where a lot of motions have been granted for disclosure, so that the patentees have to disclose their license agreements following from the obligation to make a FRAND offer. That also means that they have to explain why this is FRAND and also not, it's not discriminatory, right? So they have to refer to the license agreement. That was an obligation that comes from their FRAND commitment and under antitrust law in German litigation. So that was granted in a lot of cases. But also recently we have seen decisions where it was said that it might be sufficient for the patentee to just explain its overall licensing scheme and then point to exemplary license agreements. The courts, to some extent, deviated from these disclosure obligations. And that then necessarily raises the question, how can you, resolve this information asymmetry that still is present in those cases? There are certain ways to do this procedurally. We have, for example, in cases filed counterclaims for disclosure. Those counterclaims have been rejected on a general basis with the lower courts. And there is one specific case that we're handling that is currently pending with the Federal Court of Justice. And so they will have a view on this shortly. So that, we will see how this develops in the meantime. But bottom line is that not always the valid calculations that were done are taken into consideration at all. So I think that's my introduction.
Got it. Thank you. Thank you to all the speakers for those opening remarks. Very, very, very great. Again, I welcome, we welcome his questions via the Q&A function. And we do have one that I can ask straight away. That has come in, so I'll just read it to you. I think sparked by the remarks you just gave, Andreas. But the question is: I would be interested to hear from Andreas about whether and to what extent German courts have used valuation methodologies in determining whether an offer or counter offer is FRAND compliant. It is hard to see how such a determination can be made without some sense of what amounts to FRAND. And for this, some methodology must be used. Just reading that. What do you think?
No, I'm happy to take this. So I think, how it works procedurally is that the courts, they do not start from scratch, right? They look into the arguments of the parties, and they should look into this. And if they do this properly, then they have to deal with the valuations that have been made in the submissions, right? And well, with regard to that, sometimes, let's assume there are no license agreements in place. Then this might be one of the rare cases where you can rely on a top-down approach, right? And then there are often disputes. What is the appropriate average selling price and things like that. So that is where the courts look then into. And if they see some deficiencies with the one or other line of argument, then they decide this in favor of the one or other party. And the same holds true for comparable license agreements, right? If you have the burden of proof as the implementer, as the defendant, to show that there is a discrimination. So if you look into license agreements and you see certain rebates, right, that have been granted to other licensees, and you ask, well, why has that not been offered to us, right, to the defendant in our case here? And there is insufficient explanations with regard to this, right? Then the court will assume that there is discrimination, or the other way around. The patentee may prevail with arguments why there is a justified discrimination. So that is how they approach this. It's not that they say the courts, so we will now, apply approach X, Y, that or so. They only look into the arguments of the parties, and then they have to decide on this. I hope that sufficiently answers your question as to what methods are used in the court proceedings.
Thanks. Okay, well, yeah, please thanks for that question, and keep sending further ones in. Some further follow-up questions I can ask here. Perhaps for you, Dr. Friedl, to what extent should information be made available on past SEP valuation practices, and what are your views about NDA obligations, and are they overly restrictive for those utilizing standards? I know that in the opening remarks, some of the other panelists raised this topic, but curious about what you think about that.
Yeah, thanks, Brian, for this question. So exactly as you said, this topic has already been raised by Benno and also by Christian, and I think Christian's argument with respect to who benefits basically from this NDA disclosure deserves some attention, because it is not clear that there is only one party that basically that benefits from this NDA, and therefore the basic question is there an overarching societal demand for having transparency about that, or is it not? And this is, I think, it is difficult to answer, but at the moment, I would say the arguments are stronger for those that basically allow parties to make these NDA, to enter these NDA agreements, than to require transparency on each of these topics, because I personally, I'm not convinced from this overarching societal demand for that.
Thanks. Okay, well, maybe another question here for you, Professor Helmers. I know you described the findings of your study on the availability of information, transparency, and SEP licensing. Based on your experience, what is the impact that your findings have on small and medium-sized entities and their capacity to innovate, the linkage there?
Yeah, that's a very broad question, and I don't think anybody has the answer to that question. But generally, I think I agree with Professor Friedl that at this point it's not clear that there is a strong case for increased transparency in general. The market seems to be working, at least for the incumbents. But I think there is a valid question when it comes to new technologies, especially now in the context of the Internet of Things, where we might see entry by new firms in applications of these technologies, where the technologies are perhaps not central to the new application, but nevertheless require a license. So in those instances, I think the licensing costs might weigh heavier on decisions to actually engage in those markets and adopt the technologies. And here we are probably also talking about new players in the market who are inexperienced in licensing SEPs. And for those players, I think those issues might matter more. So there is, I think, a question whether and how information could be made available to those parties, right? And that doesn't necessarily require a wholesale restructuring of the way parties do business in the SEP licensing market.
And thank you. And by the way, if other people have responses or follow-ups on any of these questions themselves, please do jump in. But great. Well, how about for
Brian, before we move on, yes, I do have a remark on the NDAs actually.
Okay.
Because like the discussion here seems to be a little bit like, do we want to have NDAs, yes or no? But I think that's maybe not the right discussion. The discussion is, should we have certain elements that we may want to carve out of the NDAs, right? Because we see some benefit actually for all of us as a whole if we have transparency on certain of the aspects there. Now, what Christian actually mentioned doesn't surprise me too much actually, because what we see is that of course in a particular negotiation, the parties, they think that if they don't need to disclose certain things, then this is something that can help them improve their situation individually, so to say. So there's an interest actually in maybe agreeing on something that particularly attractive conditions. One thinks that this is then particularly good. One thinks that it's easier to accept this for the SEP holder if then the same conditions don't need to be offered to somebody else, right? That's often a thinking. But then of course the question is, I mean, again, do we have a very efficient system if in each negotiations the parties try, if you want, to hide certain parts of the agreements, and then basically, you know, and on the same time, they are very interested in information that is already around of previous agreements, right? So, I mean, we are in a system, and I mean, this is very much to this comparable license regime, actually, where it matters very much, actually, what I'm agreeing in one license, because this is actually something that has an impact on all of my future licenses. And that's why I have a great interest, actually, in hiding certain elements of my current negotiation. And actually, both parties might have an interest, because if I'm just about to get a particularly good agreement, and I tell the others, then I may not get it anymore, because then it's getting too costly for the SEP holder, right? So that's certainly one of the considerations. Now, do I think that the whole system makes a lot of sense? Personally, I think that this shows us actually the issues of the whole comparable license approach, right? The issue is that, and I mean, this goes also to the question of Patrick before. The issue is that instead of grappling with the substance, with the royalty rates, right? What happens is that we have a regime where we have strategic licensing at the very beginning. So the SEP holders, they are, you know, singling out particularly weak licensees, are extracting inflated rates of these licensees, and are then imposing these rates to the stronger potential licensees. And then basically in these later negotiations, one then needs to defend against these inflated rates that have been, you know, imposed on firms that can't really, you know, bear the costs for the assessment and for the litigation, right? Now, is this a regime that is particularly effective? Is that a regime that we want to maintain in the long run, in particular on the Internet of Things? I have to say I'm skeptical here. I mean, like by now we have you know, a decade of academic publications where this problem has been identified actually and clearly spelled out. I mean, it has you know, even a name, so to say. So one knows that there's the cyclicality problem, right? And so I'm wondering whether it is not time actually to you know, to make very clear that we can't just rubber stamp earlier license agreements, and we can't just simply pretend that these earlier license agreements, you know, have all been agreed upon, you know, without any pressure of injunctions. And you know, that basically just because two parties agreed on a rate, this doesn't mean that this rate is fair. It can very well mean actually that this rate is inflated. And I think we need to increase the awareness actually of this issue.
Yeah, thank you for that intervention. And I think that almost kind of gets a little bit to a question I was going to throw your way next, in that, you know, building on what you just said is, I don't know if you have any views about, you know, is there a broader competition issue linked to here, and perhaps, you know, is there any way that we all of us can solve this issue? and also, if other people want to give an answer in any form to that, it's great too.
Yeah, look, I don't want to capture actually the discussion, so let me be very brief. I do think, I said it already, I do think that there's a broader competition issue here. I do think actually that what we need to have more of an awareness of what standardization is about. I personally, I believe that, you know, the issue is that standardization takes away options from you know, all parties that are at the table, in particular of the implementers. They are forced to implement a standard. I mean, in cellular, nobody can use a different technology than 4G, 5G. Everybody is locked in if you want, right? And I think we need to have awareness, because the way how currently SEP valuation is done is, you know, almost ignoring this whole issue. So if I look at again, I'm German, if I look at the German courts, I mean, there seems to be the impression actually that, you know, if one negotiates after the standard has been developed, everything is fine. You know, all options are still on the table, but that's of course not true. I mean, like, one needs to look carefully into what's happening. And, you know, if you ask me for solutions, and again, I want to be very brief here, I think that what we need is, you know, increasing the transparency and having a bit more of a push, you know, in having transparency before actually the players are locked in. So, and I mean, again, this brings me back to the you know, initiative that I had already mentioned before. Is there something we can do to, you know, increase actually the clarity on the standard developing organizations IPR policies, right? Can we give a bit more of a meaning to FRAND? Can we have SDOs that are already clarifying certain aspects of the FRAND concept? I mean, again, if I take the IEEE, I think it's a very good example. I mean, they have clarified that they want to have a license to all, and then they have also basically clarified the positioning in respect of component level licensing and certain valuation aspects. So if for future standards, if you want, if we have at the very beginning where an SDO is created, if at this point in time these SDOs are taking position on these aspects, to me this is something that is uniformly good actually, because everybody knows then what's happening. If this gives clarity to and certainty, if you want, or high degree of certainty than otherwise to the implementers and SEP holders, they can of course always kind of look out for an alternative SDO that maybe has different terms, and then come up with a competing standard. But then one has more competition of standards. I think that's something that's very valuable actually.
Great, thanks. Okay. Appreciate the questions coming in here. But why don't I ask Andreas, perhaps a question for you, if that's okay. What are the legal implications of having a general lack of public pricing information in relation to compensation for SEPs, particularly upon the awarding of patent infringement damages from your experience?
Well, patent infringement damages does not really play a role in German litigation. So that might be different in the US and other venues, right? But as a plaintiff, you go to Germany because you would like to take advantage of the threat of an injunction, right? When it comes to damages, the German system is really based on a compensation-only approach, right? So, and it's always a very uphill battle for a patentee to get those damages, right? They have to file for various proceedings. You will not get that in first instance. You will only get a declaratory judgment for damages. Then you have to enforce claims for information rendering account. You have to analyze them. You have to, calculate what is your damage on this. And as it's based on compensation, it is mainly about a reasonable royalty rate, right? And there, obviously, this entire issues pop in again. But this hasn't been decided in German litigation, as far as I know, because it's very unattractive, and you will only get damages for the German patent, right? Only for the German part of the European patent or for a German patent itself. So that is only, when we speak about portfolios, it's only a very minor fraction. It's not worth having litigation about this at all. And that is why we simply lack case law here. But it would be about a reasonable royalty rate, and then you're back with all the assessments in terms of FRAND.
Thanks. Okay. Well, let's see here. Another question, and or really, it's kind of a concept that I thought we could ask about and try and bring in and see what you all think about. But perhaps we could start with you, Dr. Friedl. With the rapid growth in IoT development and innovation, what measures should be taken to avoid, the royalty stacking effect? The idea that SEP royalties would be inflated to the point that it would make it uneconomical to develop the product. And as I think about like a connected coffee cup, even, right? That's maybe not exactly the highest amount of public utility there. Something of a nice to have, but nonetheless, newer connected products throughout the consumer and enterprise context. Wondering if you have a view about the enforcement of FRAND commitments between SEP parties and in this respect with royalty stacking and anyone else?
I am not really concerned about royalty stacking in cellular technology because what I see is that there is a lot of transparency about, let's say, the contributors to the technology and their patents that they hold. So there is basically there is a number of standard essential patents for 4G and 5G technology, but there is also, I would say, enough transparency so that within negotiations, the royalty stack plays enough of a role so that this is then not an issue in the ultimate price. So I'm not really concerned with that. And maybe, I mean, when it comes to transparency, it could be valuable to get even a bit more of a transparency about who basically contributes to a standard and to what extent, and all this essentiality discussion that we have. I mean, here I think there are a number of studies on the table that basically explain the contributions and that try to basically come up with which party has what share of essential patents, but improving that from the perspective of the standard setting organizations, it could be valuable in my opinion. So I think here the standard setting organizations could help in bringing even more transparency on the table. But ultimately, my concerns here are relatively, I'm not really concerned here.
Anyone else have a? Okay.
I'm happy to jump quickly in if that's fine, Brian.
Yes, please do.
So I'm seeing a connection between, you know, transparency or the lack of transparency and the comparable licensing approach, which is actually the predominant evaluation approach used by German courts. And you know, also it's also used, of course, more widely in Europe. Now, my concern is that, you know, as I mentioned already before, we have these strategies, you know, which are, you know, it's understandable why this is done. That in particular, weak licensees are approached first, then one tries to kind of create these, you know, inflated precedents, and then one tries to roll these out across the industry. Now, one problem is, of course, that these poor weak licensees, if you want, at the very beginning, they have very poor information, and they often, you know, often those licensees need these standards for particular products where if you want, more value is generated from complementary innovations and complementary investments. So in that sense, if you want, they have a higher willingness to pay sometimes to take an economist jargon, right? So they have a problem because they have very poor information. Sometimes they just want to get rid of the licensing problem. That's why they're entering into an agreement at possibly inflated rates, and then basically all of this takes its way, right? Now, what would happen if these weak licensees have more information at their fingertips? Then it might actually be already more worthwhile for them to defend themselves, at least a little bit more, and this might already, you know, alleviate to some extent at least the issues that we are seeing here, right? So in that sense, I do think that transparency is not only a means on its own end, it is also something actually that directly has an impact actually on the royalty rates that we are seeing. And I mean, there have been concerns expressed about too high rates, especially when it comes to an IoT environment.
Well, thanks. Okay. Well, why don't we? I'd love to. We can kind of look at some of the, you know, what can we walk away from our discussion with and thinking about solutions. You know, if it's okay, Christian, maybe, you know, what kind of suggestions do you think you might see as ideal to increase the lack of transparency that you were mentioning that you've just identified. If there's any that you want to offer.
You're asking me the most difficult question. I don't think I have a good answer, but I like Dr. Buehler's suggestion of certain carve-outs when it comes to secrecy. So, for example, disclosing who has already taken a license, right? Potentially with some additional information about the context, without having to disclose terms, specific terms or rates. I think that might be valuable. But again, I think one has to be really careful mandating more transparency without actually understanding why we have the current setup where there's relatively little public information about licensing rates and terms, right? And I think to some extent, I worry, of course, just like Dr. Buehler, about the opportunities that that provides to certain players to behave opportunistically, right? To obtain strategic licenses because they understand that then later on those licenses can be used to increase royalty income. But one has to also take into account that to a certain extent, that's the outcome of the framework that's been imposed on the ecosystem, right? So licensors understand that the initial licenses will be crucial later on when negotiating license terms with perhaps more important players. So it makes perfect sense for them to behave strategically, right? So whenever one intervenes there in the market, one has to take those things into account. It's often not as simple as simply mandating more disclosure, because there might be unintended consequences to that. So in short, I don't think there is, I don't have a straight answer for you, but I would suggest that others look into this more and try to understand what the role of transparency really is for the functioning of the SEP licensing market.
Great, thanks. Well, I suppose maybe I could think of maybe one further question. It really, I'd be interested in everyone's kind of viewpoint here from where they sit, their experience, and a little bit of a preface for this question. Where I'm coming from with it is there's interestingly, through the construct of a standard setting organization, been a pretty successful attempt, I think, to develop as much of a consensus as possible around core principles and best practices in a way for SEP licensing. The standard setting organization construct that was used was Sensenelec. And there was I'm mentioning this because we were our organization among I think 25 others or something like that were part of this organization that worked on these best practices. A pretty diverse group, inclusive group, and the work product is called CWA 95,000 Core Principles and Approaches for Licensing of Standard Essential Patents. And so I mention all that just as a little bit of background. One of these kind of relative, pretty core values has been that that licensing valuation should be independent of the level of the supply chain at which the license is taken, for example. And I'm curious if you all see that to be, is that reflected in practice out there? Does anyone have any view on that?
Well, I think that was the core of the Nokia-Daimler dispute, right? and there were different approaches by the courts. So what we've seen, for example, with the Munich Court agreed with the patentee, right, that the patentee shall have a choice who to attack in the supply chain, and that those being attacked cannot invoke, a FRAND defense of their respective supplier that is willing to take a license. So that was the core dispute, and we know that the Düsseldorf court disagreed with that, and they made the referral to the CJEU. And they not only raised questions, but they also provided answers in terms of how they see it, right? So they provided a very comprehensive rationale of their views, and that was clearly that a license should be available to all players in the market that would like to have a FRAND license. So that is clearly a license to all. That was the answer of the well-reasoned answer of the Düsseldorf court. So in practice, this has not been clarified, so to speak. And I should add that, since the litigation settled, right, also the referral question that were at the CJEU will not be decided, right, because the case was withdrawn. So it would make sense in further litigation for one of the courts to refer this again to the CJEU to have some more clarification on this, because that would then be a guiding principle for the entire market.
I mean, the general question is basically what is the economic contribution that a patent or a technology basically brings on the table, and this economic contribution should be the basis for the patent value. And this is not so clear because there are interaction effects between the technology, for example, from cellular technology, and then other inventions that interact with connectivity, and disentangling these effects and bringing them that on the table, that would be the requirement here. So there could be no clear yes or no answer here. It basically depends on which technology you're referring to. I mean, it's clear if you do something like the SSPPU you approach when you license at the very first step or in the value chain, then it's it is not clear whether the patent owner gets enough from the value of his technology. But at the same time, there are so many inventions typically within a value chain, and all these inventions also should get a share of their basically contribution, which are different from, let's say, connectivity when we come to. So I think this is you need to basically go into these topics very deeply, and you cannot answer this question basically with a clear this is the right answer or this is the wrong answer.
Maybe I can jump in here if that's fine. So actually this question that you raised, Brian, brings me back to my earlier comment, because we need to distinguish here, right? So on the one hand, courts are trying to clarify certain aspects of FRAND generally, right? They're trying to clarify this, if you want, ex post for Etsy, for cellular, for example, something that has been left open so far for interpretation, right? So of course that is of course a challenging question then, but of course, and just to repeat, of course STOs have the freedom to define in their IPR policy, and IEEE has done it already, that, for example, licensing should be done to everybody, right, to all, or that, a certain valuation concept should be used. So, I mean, I think it's very important. We're talking about FRAND, but FRAND is not, FRAND is not, a single concept, if you want. FRAND can be very different depending on the IPR policy of the SDOs. So I only invite actually SDOs to use that freedom and clarify, define, how they see it actually. And then I think the only point to mention here is that, of course, I came from the European Commission. Of course, there in the horizontal guidelines, there were all the, a few safeguards, because there is, of course, the concern that that one needs safeguards in order to prevent holdup. So there must be always, some limit. There shouldn't be any scope for holdup and for exploiting locked-in implementers. That's clear. But when but in the other direction, if you want, I personally think that there should be all flexibility available. So like we see standards that are done on a royalty-free basis, right? Entirely zero, and that's fine, that works, right? Why shouldn't it then work to, define that, one has very implementer-friendly terms, although one has, some payment. I mean, I should say that there are some standards out there where we have very implementer-friendly terms and still they're not entirely royalty-free, so that works. And I think that this is just something that, needs to be pursued also later on, if you want. The problem that we are facing here with the clarification of license to all versus access to all is, is an implication from leaving certain things open at the IPR policy stage. ETSI hasn't clarified that point. That's why now courts need to jump in and clarify that, right? So that goes again to my earlier comment, that I think it would be a good development, and I think that we should have, more diversity at the IPR policy level.
There's also a further layer when I come back to German litigation with regard to this, because in German litigation, different than with the US and UK, you cannot directly rely on the FRAND commitment by the patentee as an implementer, because under German law, you're not considered as a third-party beneficiary. So you would have to rely on antitrust law, right, to come to the FRAND defense, to its applicability, and that requires a market dominant position and so forth. So there are different requirements under German, from the German litigation standpoint here, and it might make sense to also include something like that, in the FRAND commitment, that it is to be considered as an agreement that third parties can rely on, right? So also from a litigation standpoint, those contractual undertakings can be improved. Yeah.
And I mean, I realize that basically I'm capturing quite a bit of speaking time, so I hope I can still kind of add one more comment.
Yes, please.
So I mean, also adding to the comment that Professor Friedl has already mentioned on the on the valuation, on whether licensing at different levels in the licensing chain should have an implication on valuation. So I totally agree, actually, that in the end, of course, this is a question of apportionment. We have one value that's created, and we need to find out kind of what part of that value goes to to which stakeholder, if you want. And there again, my earlier comment, this is something, of course, I mean, we are having a discussion, a general discussion. How should apportionment be done if something has been, has not been defined clearly yet, right? Of course, there can be also a different world in which, an IPR policy has already taken views, such as, for example, in IEEE, where there have been already certain clarifications on how valuation should be done. So we're talking here about a question of apportionment. Now, one important question is, should apportionment differ depending on which level in the value chain we are licensing? There I hear often, especially from academics, no, it shouldn't actually. Why should they be different? It's the same value that's created. It's, it's a kind of reasonable comment. But then, of course, a different question that we need to ask ourselves is in practice a difference in the apportionment? So do we see that if we are licensing, for example, at the end device level, do we see then a systematically higher share going to the SEP holders, possibly an inflated, a very high and excessive share, right? I think that is a question we need to ask ourselves. So we need to ask ourselves, could it be that in theory there shouldn't be a difference, but could it be that in practice we are seeing a difference? And that's maybe why we are seeing such a push from certain SEP holders to license at the device level. I mean, that's something that we are seeing right now in IoT, right? I mean, if I think about autonomous driving and so on and so forth, I mean, there has been quite some dispute on whether this should be licensed at the component or at the device level, if you want, at the end product level. And I'm wondering, is this dispute to extract more at the end device level, if you want, or are there efficiency considerations that are that would maybe speak in favor of doing it on one or the other level? And I mean, we need to be very careful that in the end we're not ending up with something that is less efficient only because it maybe generates higher royalties. So I think that it's very important to keep in mind to make this distinction between in principle, what do we want, and being very conscious about implications of practical choices in practice.
Thank you. Thanks. That's great. Anyone have any reactions, closing thoughts?
My concern about flexibility, about the decision where to sue along the value chain is mostly about, again, opportunistic behavior. So if licensors have flexibility, which
Exactly.
I think from an economic perspective, it makes a lot of sense to grant that flexibility because, as Professor Friedl said, it is not a clear-cut decision, and it might really depend on a specific technology or market context. But that flexibility might again offer an opportunity to licensors to behave strategically and thereby extract inflated royalties. And I think that is the downside. But again, it's simply a trade-off between regulating, right, coming in and providing less flexibility or restricting that flexibility, and perhaps restraining a licensor's ability to behave opportunistically versus granting flexibility that is economically warranted, right? Yeah.
Yeah, this in the Nokia Diamond litigation that we have just mentioned, there was also this argument raised by Nokia that it would be more efficient to only license the end product. The counter argument of the Düsseldorf court in their referral decision was that if you look at efficiency, it would be most efficient to license the chipset manufacturers because there are only 10 or so worldwide. So that would speak against efficiency here. Obviously, they do also not want to take the burden for the rest of the world here. But those are the issues. There are always counter arguments.
Great. Well, thank you. I mean, it's a great discussion. I mean, this is excellent. I know that that there was a few closing remarks, and I should turn it over to Morgane here in a moment. But truly, this has been really excellent and engaging, and I think for the audience, I feel really confident in thanking all of you for your time and expertise and dialogue here today. Very valuable and helpful. Morgane?
Yes, well, thank you very much, Brian. And well, I think this brings today's event to a close. And I think you'll agree that we managed to shed some light on several of the valuation issues that are at stake in SEP's negotiation. And I would like to express really my gratitude to all the speakers and panelists for providing us with such a stimulating discussion. And also a sincere thanks and appreciation to the audience for your participation today. Feel free to check our website for additional information on today's event, because we're going to publish a recording of the event and also some a report about it. And you'll also have access to all the previous recordings of the other events we did part of this series. So thank you again, and stay tuned for potentially next episodes of this series. So thank you again.